Great, we'll go on the record in the state of Wisconsin versus TERRELL Hampton. It's 26 CM 584 appearances.
Casey Dice for the state.
TERRELL Hampton appears via Zoom video teleconference from a segregation cell of the Dane County Jail. Here in the courtroom is Attorney Will Anderson of the Public Defender's Office, representing him specially for today's purposes. Mr. Hampton, have you received a copy of the criminal complaint in this case? Could you maybe make a thumbs up if you have? Or bailiff?
I think I see a thumbs up.
I see a thumbs up as well. Excellent. And so he's received a copy of the criminal complaint. We'll waive its formal reading. Ask the court to enter not guilty, please. Let's see. I have a note here that he is eligible for a public defender in this matter. Was unable to provide a mailing address to my office this morning. So for now, let's leave the mailing address as is. And I believe that's all you need from me, right?
Right, I'll make a finding of probable cause that are not guilty plea. I was informed that there might be a victim in Mr. Hampton's case who wanted to make a statement. If they're on the Zoom call, just unmute first and then identify yourself, and then you can let us know what you think we should know about your thoughts on bail or bond conditions.
Hi, my name is Tracy Moore. He can be given a bond. I just don't want him back in my house.
Okay, so you would like him to have no contact with you and be banned from your house?
Correct.
Okay, and anything else that you wanted to say, ma'am?
No, I just fear for my safety. I don't want him there anymore. That's it.
Okay, well, let me turn to the state and see what their position is on bail.
The state is likewise supportive of a signature bond with the condition not to have contact with TAM, that's Tango Alpha Mike, and not to be any place where TAM works or lives.
Great, any objection?
Well, Your Honor, I would, no objection to the signature bond. You know, I haven't had a chance to speak to Mr. Hampton, but I would note that the address on the criminal complaint is the address where this alleged act occurred. And according to the information in the criminal complaint, the defendant and TM have been married for approximately 13 years. So I guess on that understanding that she is asking for a ban from the address, I think that would have the effect of rendering Mr. Hampton homeless. So I would object to that condition for that reason. Thank you.
All right, any response from the state?
Your Honor, relationships dissolve every day in America, and every day somebody has to find somewhere else to live. The defendant's charged with a crime. He came back after committing a crime on March 2nd. He came back on March 14th, caused a new disturbance. He just can't be at that house anymore. And if he wants to go to family court to dispute ownership of the house, etc., as the dissolution of the marriage progresses, so be it. At this point, for society, for TAM's safety, he needs to not be there.
All right, well, I think TAM's within her rights to ask for the no contact. She's not charged with a crime. In reviewing the complaint, it sounds like there's maybe been stuff in the past as well. If she were to just slap a copy of the complaint to a restraining order, it would be granted and he'd be kicked out of the house until a hearing in the next 14 days. I think it's an appropriate request. I'll order the signature bond. I'll order no contact director and direct with TAM, her residence or place of employment. Mr. Hampton, when you sort out where you're going to be able to reside, just make sure that you let your attorney know so they can update your mailing address with the court. And we'll be adjourned.
Next up is Robert McGee.
Yes.
McGee? Great, we'll call the state of Wisconsin versus Robert McGee. It's 26 CM 601 appearances.
Casey Dice for the state.
Mr. McGee appears in person in custody alongside student intern Luke Begley under the supervision of attorney Anderson. Begley spelled V as in Victor, OEGELI. We have received a copy of the criminal complaint and waive its formal reading. Mr. McGee is eligible for public defender services.
And is the address on the complaint the best place for him to get mail?
Your Honor, that would be 2601 Pheasant Ridge. Department 7.
All right, we'll get that updated. I'll make a finding of probable cause. We'll get a not guilty plea entered. There's a public safety assessment report. It recommends a signature bond. State's position on bail.
State is supportive of a signature bond with non-monetary conditions of no contact with Noah K. Noah is spelled like in the Bible. No contact with Dylan W. Like Bob Dylan, and a ban from any pawn or resale store.
No objection, Your Honor.
Okay, we'll order a signature bond. Conditions will be that you have no contact, direct or indirect, with Noah K.
What's Noah K?
That's
That's a person.
one of the alleged victims. Noah with the last initial K and Dylan with the last initial W. And then a ban from any pawn or resale shops that purchase items from the public. And we'll be adjourned. I think you're gonna get released today, Mr. McGee.
Thank you.
Yep, you're welcome.
I'm sorry.
Molitor?
Well, I got a court date.
You need a moment to get set up. Are you all good, Attorney Blair?
I am all good. Thank you. I apologize for being late.
Oh, you had a pretty good excuse, so it's all in here.
All right. And I'm sorry, the next,
I didn't catch the name.
that's an M.
Patrick Molitor.
Got it.
Great, we'll go on the record in the state of Wisconsin versus Patrick Molitor. It's 26 CF 662 appearances.
The state appears by Assistant District Attorney Thomas Valerio. Good afternoon.
And Patrick Molitor appears in person and in custody, represented for today's purposes by Attorney Will Anderson of the Public Defender's Office. Has received a copy of the criminal complaint, would waive its formal reading. The address on the criminal complaint is an accurate address for him. At this time, he is not eligible for a public defender. Thank you, Your Honor.
All right, so let's talk about that. Mr. Molitor, you got the right to an attorney. If you can't hire one after today, you can always reapply with the public defender. The deputy is going to give you that information. The other option is you can apply for a county attorney. That's the middle option. We'll make a finding of probable cause and are not guilty pleas to the misdemeanors. We do have a public safety assessment report. Recommends a signature bond. What's the state's position on bail?
I have no objection to a signature bond. I would ask that the defendant not use or possess alcohol, that he have no unsupervised contact with child victim 1 for the purpose of the bond notes that child victim's initials are LRM as in Mary.
And any objections?
May I just have one moment to speak to Mr. Molitor?
Yes.
Thank you, Commissioner. No objection to the signature bond or the non-monetary condition involving alcohol. Would just look for a little clarification on unsupervised contact with the child victim. I believe it is Mr. Molitor's child and that he had at least some custody or guardianship of the child. 50-50, he says. So just what exactly would be meant by supervised? Who would be an appropriate supervisor?
I think typically it's another responsible adult, but I don't know if the state had something different in mind.
I think that's what we were envisioning too. So with under the supervision of another responsible adult.
So it could be anybody who's an adult.
Family, ex-wife. Okay. Then we would have no objection to that condition as articulated. Thank you, Your Honor.
All right, so we'll order a signature bond. Condition will be that you not possess or consume any alcohol, that you not have any contact with LRM, unless you have a responsible adult to supervise. You do have the right to a preliminary hearing in 20 days, and Attorney Anderson may talk to you about that a bit.
Sure. So one business days for your next, if you're gonna hire an attorney, I wanted to set a status conference. Get that attorney, get them up to speed, but if you'd rather have that one set, you know, the judge and. So just, that is, so, sure, it's got something to just be informal, to tell the court, I've already kept my preliminary. Okay, as opposed to actually. Good. That's but that's okay. I'm also like. Yeah. Just given everything, I'd like to leave the time limits intact, Commissioner,
Yeah.
for the prelim.
And it's not gonna give you a lot of time to get a lawyer. If you can't hire one, make sure you give them the public defender a call. You get reevaluated. The other thing is they can point you in the right direction to get a county attorney so you can have a lawyer for that hearing. Right, we are
Just
adjourned.
make sure you don't miss it and work on getting an attorney before then, okay?
Get the next court.
They'll set you up with that. They'll also send it to you.
You're gonna have to sign your bond. They'll get you your next court notice back there.
All right,
All right.
good luck, Mr. Mayor.
So it's 10 more.
Good.
Yeah. Great, we'll go on the record in the state of Wisconsin versus Tristan Moore. It's 26 CF 642 and 26 CM 586 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Ms. Moore appears in person in custody by student intern Luke Vagley under the supervision of Attorney Anderson. We did receive a copy of the criminal complaint and waive its formal reading. The address is correct, and Ms. Moore is eligible for public defender services.
I'll make findings of probable cause. We'll get not guilty pleas entered to each of the misdemeanor charges. Don't believe we have a public safety assessment. There was a signature bond set in 26 CF 642 though, back on February 24th. The conditions there were a no contact director and direct with ZER and a ban from the 800 block of Cedar Street in Madison. At that time, a complaint hadn't been filed. It's my understanding we may have a victim who wanted to make a statement in the misdemeanor case on Mr. Moore's case. I think I see that person on Zoom if they want to unmute and identify themselves.
Hello, my name is India Trouble.
You said Tribble?
Yes,
And is that TRIBBLE?
yes, sir.
All right, and Ms. Tribble, what did you want to say about bail or bond?
Well, I wanted to unlist the no contact and his bail and bond to be dropped low. Yeah, because he helps me. He's my caregiver. So we just started working with that, and I was wondering if he could be banned from Cedar Street, because there really was no point in him being banned from right here. Because from my understanding, they say he's banned from my unit, which I never put that in place, or I never understood that was in place. So.
Well, it's possible that it wasn't something you requested, and I don't know that it was a case involving you. I think another case that he's got, a more serious case, a felony charge, that ban was entered in a no contact with somebody else. Anything else you wanted to say, Ms. Tribble? Okay, thanks for your input. Let me turn to the state and see what their position is.
In 26 CF 642, it looks like, as you mentioned, there wasn't a complaint originally. So I think all we're asking is that you continue the bond conditions that are previously ordered in that case. So that was a signature bond, no contact with ZER and a ban from the 800 block of Cedar Street. And then in the newest case, which is 26 CM 584. I'm requesting a $500 cash bond in that case. I'm asking that the defendant have no contact with India T, and that the defendant be banned from the 800 block of Cedar Street. And also specifically, I would ask that the defendant not be allowed in the building of 815 Cedar Street. 1 second. Well, now that I'm looking at it, it's incredibly concerning that, I recognize that a complaint wasn't filed in 26 CF 642, but it looks like the defendant was still ordered to be banned from the 800 block of Cedar Street. I just wanted to make sure that this happened at Cedar Street.
Well, and I had a question, and maybe now's as good a time as any.
Okay.
So there was a reference about a violation of a no contact with India T at the time of this new misdemeanor case. It referenced he was out on bail on another one, but it didn't allege, unless I overlooked it, that there was a specific violation of a no contact. So I wasn't clear if there's another case involving the same victim and then there was a no contact. It was charged out as a no new crime bail violation.
Okay. My understanding is that in 26 CM 294, that's the only other case I'm aware of that's pending besides the two before the court today. It looks like on February 5th, there was a no contact with India T ordered. But I agree that the way that the 26 CM 586 case was charged, it alleged a no new crimes violation. And I think that's obviously from the, I believe the obstructive or resistive conduct here. Still, I believe the criminal complaint still lays out facts indicating that the defendant was still in contact with,
Yeah, so it looks like the no contact is still in place as I look at 26 CM 294 with India T. That case obviously isn't before us, so I don't have any authority to do anything with that.
right. And I think my point here is that it's alleged that Mr. Moore, that Tristan Moore is at India T's apartment, and that he runs from law enforcement when they try to detain him. So I think that the fact that the defendant is violating condition of bail by engaging in new criminal conduct and their conduct at the scene, I think that merits some cash bail.
All right, and any response from the defense?
Your Honor, we're asking for a signature bond today. Mr. Moore has been a lifelong resident of Dane County. He has parents here, siblings here. While he's not currently employed, he is looking for a job and is currently a caregiver for his father, who's visually impaired, helps him get to places such as the grocery store. That's all, Your Honor.
All right. And aside from the other pending cases, is there a prior history that Mr. Moore has?
Yes, so it looks like Tristan Moore was convicted of misdemeanor battery in 2025. It looks like that was originally in 2025, that was originally a DPU disposition in 2023. The defendant was sentenced to 2 years of probation after that didn't work out. And then I see a conviction of disorderly conduct on that same day, March 10th, 2025, where they got a year of paper as well. Then I see on March 10th, 2025, a conviction of theft from person or corpse, where they were placed on 3 years of probation. So that means that the conduct here allegedly occurred while the defendant was on supervision as well. I'll also note that as it involves those cases involve different victims. In the past, in 25 CF 1749, the defendant was convicted on October 30th, 2025 of misdemeanor battery against India T, who's the alleged victim in that, who was the named victim in that case. That's my understanding of their criminal history. I will also note, I failed to mention, looks like a bench warrant was issued on February 12th, 2025. In fairness, it looks like that was canceled, though it was canceled in March 10th of 2025.
All right, I should allow the defense an opportunity to respond to anything.
As far as I'm aware, Your Honor, I'm not aware of any missed court in the past. I would just like to add that.
All right, well, here's where I'm at. It's concerning, I guess he got a break. He could have been charged with a felony bail jump out of the GF file, even though a criminal complaint hadn't been filed. The law says that that can still be a bail violation. You get charged for that. Looks like he also could have been charged for a specific violation for violating the no contact with India T. So he was violating bail in a couple of cases. Obviously the CF is extremely serious. He's got prior violent convictions. I think there's a need for cash bail in both of these cases. I'm going to set $1,500 in the felony file. I'll continue the no contact direct or indirect with ZER, a ban from the 800 block of Cedar Street. The fact that he was violating that specific condition in an Act 3 eligible offense suggests that something more than a signature bond is necessary at this point. In the misdemeanor, despite India T's wishes, since there's already another case that I can't address the bail, I'm not going to have inconsistent contact provisions. So I'm going to order the no contact with India T in this case as well. They're misdemeanors. They should go back to the same judge. You can have your attorney file a motion and have that reviewed. India T has the right to ask the judge to review that, but let's just be consistent with the no contacts. And I'll order a ban from the 800 block of Cedar Street. I think it's surplusage to add 815 Cedar Street when you're banned from the entirety of the 800 block that would include 815 Cedar Street. You're going to have the right to a preliminary hearing in the next 10 days. Do you want to have that scheduled within the 10-day time limit?
Yep.
500 on the misdemeanor, 1,500 on the felony.
Your Honor, we do not waive time limits on the prelim.
Okay, we'll be adjourned.
Next up is Kenneth Banks, via Zoom.
All right, we'll call the state of Wisconsin versus Kenneth Banks. It's 26 CM 577 appearances.
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
And Kenneth Banks appears via Zoom teleconference from a segregation cell at the Dane County Jail. Mr. Banks or bailiff, could we confirm that you've received a copy of the criminal complaint in this case? Either hold it up.
I couldn't catch that, Mr. Banks. Maybe give us a thumbs up in the window if you got a copy of the complaint and you can hear us. And it looks like he may have sat down, so I can't see him. Okay, there we go. So, Mr. Banks, if you can hear us okay, and you got a copy of the criminal complaint, can you give us a thumbs up in the window?
Yes, sir. I hear you, Judge.
Okay, perfect.
All right, excellent. Waive formal reading of the criminal complaint. Ask the court to enter not guilty pleas on Mr. Banks' behalf. It looks like he would like to update his address to care of the Madison Senior Center.
Yes,
At-
that's where I'm getting my mail now.
Yes, sir, and we'll get that on the court record for you. The street address is 330 West Mifflin Street. That's in
Yes.
Madison, 53703. And I have a note that he has applied for and been deemed eligible for a public defender in this matter. Thank you.
All right, I'll make findings of probable cause, enter not guilty pleas, state's position on bail.
I have no objection to a signature bond in this case. I would ask that the defendant have no contact with KMW or JMK.
Your
And that the
Honor,
defendant-
I don't even know who these people are by its initials, by face or name. I don't even know these people.
Okay, so you probably shouldn't have any reason to have any contact with them in the future.
Yes, sir. I mean, I don't even know these people. I don't know who they are. If you asked me to point them out right now, I couldn't.
Okay, well, it's only a bail violation if it's proven to be a knowing and intentional violation. But let the DA finish with their requests, and then your lawyer will have a chance to make any arguments on your
I'm sorry
behalf.
for
And
the interruption.
and if you need to meet with them, that's fine too. But go ahead, Attorney Valerian.
I'm also asking that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription.
Great, and Attorney Anderson, any objections, or do you need to speak with Mr. Banks?
Mr. Banks, I don't think I'm going to raise any objections to this. As the commissioner points out, if you don't know who these people are, then you won't be having knowing intentional contact with them, okay? You will get
Yes,
some
and
report.
pardon me, but another thing the judge said is that I have a grade 3 sciatica. So what happens is once every 2 weeks, I go out to UW where my back specialist is, and they give me 1,500 milligrams of cortisone to deal with my back issue. But other
Right,
than
but
that,
that's prescribed, and so they're just asking that you not have any controlled substances that are not prescribed to you lawfully. So that shouldn't be a violation to get
so
the
I can still
cortisone.
go see my doctor and get my back medication.
Yep,
Yes, sir. Anything prescribed to you would not be a violation of your bail conditions, okay? And you just can't have intentional contact with the alleged victims in this case, okay? And they'll let you out of jail today, okay?
Yes, sir.
All right.
I don't even know these people.
all right. I'll order a signature bond. Conditions will be a no contact direct or indirect with KMW or JMK. That you not use or possess any controlled substances or drug paraphernalia unless you have a valid prescription. We'll be adjourned. I think you're getting released today, Mr. Banks. I don't see anything else holding you.
Could
Take care.
anyone tell me what my next court appearance will be?
You're gonna get all that paperwork before you leave. You're gonna have to sign your bond, and on, actually right above your signature will be the date and time of the next court date, and they'll give you a copy of that. You're entitled to all that paperwork.
Oh, okay, Your Honor, thank you.
Yep, you're welcome.
Next up is Jamal KRAUSE-SIMMONS.
KRAUSE-SIMMONS. All right, we'll call the state of Wisconsin versus Jamal KRAUSE-SIMMONS. It's 26 CM 609 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Jamal KRAUSE-SIMMONS appears in person and in custody, represented for today's purposes by Attorney Will Anderson of the Public Defender's Office. He's received a copy of the criminal complaint, will waive its formal reading and ask that the court enter not guilty, please. At least for the time being, that's supposed to say, right? This is requiring address for mail. So you want to change it? Okay. For the time being, the address on the criminal complaint is a good mailing address for Mr. KRAUSE-SIMMONS. And I have a note here that he's applied for and been deemed eligible for a public defender in this matter. Thank you.
Great, I'll make findings of probable cause and are not guilty pleas to the charges. The public safety assessment report recommends cash bail. What's the state's position on bail?
Sorry, 1 second. Okay. I actually have no objection to a signature bond in this case, Commissioner. I would ask that the defendant exhibit no acts or threats of violence towards ZJC, and that the defendant be banned from the 200 block of Bird Street in Sun Prairie, Wisconsin. 1 second. Let me make sure. Sorry, I'm just trying to figure out if that's where ZJC lives.
Hold on. He's talking, right?
Looks like the defendant's address is in the 200 block of South Bird Street in South Prairie. I'm guessing this is supposed to be South Bird Street.
Right. All right, I'm looking at the criminal complaint. It looks like law enforcement was dispatched to a South Park Street address.
2222 South Park Street, according to the PC affidavit.
Right, so I think it might be more. Well. But I believe the complaint also alleges that a witness named MRW stated that the female and defendant reside together on South Bird Street. All right, still, nevertheless, Commissioner, it looks like the victim in this case wanted contact with Mr. KRAUSE-SIMMONS. I'm looking at well, it actually looks like there's a currently open case involving misdemeanor intimidation of a victim and battery regarding ZJC. Okay, I apologize. My notes are a little disorganized on my end. I'm amending my position. Commissioner, I'm asking, I have no objection to a signature bond. I would ask that the defendant have no contact with ZJC and that the defendant be banned from the 200 block of Bird Street in Sun Prairie. I will note again, the alleged victim in this case would like contact with the defendant. However, given the fact that it appears to be a different case currently pending and it alleges an act of misdemeanor intimidation of a victim, I do think at this point the no contact is appropriate. I think the address ban, which I believe is where the alleged victim resides, is also appropriate.
And is that other case the 26CM245 case? Yeah,
Yeah.
looked like it.
Yes.
Got it. All right. What's the defense position?
If I could just have one quick moment to talk to Mr. KRAUSE-SIMMONS.
Yeah, that's supposed to be South first, right?
Yes, sorry. Thank you.
Thank you, Commissioner. No objection to the signature bond. We would object to the non-monetary conditions and ask instead for a no threats or acts of violence condition. I understand from both what the state has said and also from what Mr. KRAUSE-SIMMONS has told me is that the alleged victim in this case does desire contact, does wish for him to be able to return back to the shared residence on South Bird Street, where they have a child in common that lives there with them. They also have pets that Mr. KRAUSE-SIMMONS cares for, and that is primarily what I have for your honor. Thank you. I would ask that you consider a signature bond with the non-monetary condition of no acts or threats of violence. Thank you.
All right. Any response from the state?
In the underlying case, 26CM245, it's alleged that the defendant is engaging in not exactly the same conduct, but still similar conduct where there's an argument. It's alleged that the defendant pushes the victim into a shelf, causing her pain. And then it's alleged that Mr. KRAUSE-SIMMONS gets his hands on her phone and tells dispatch that everything is fine, that she used Siri to call 911. And that happened in January of this year. And just a couple months later, not even a couple months later, Mr. KRAUSE-SIMMONS is allegedly battering ZJC again. He's violating a specific condition of bail by engaging in allegedly acts or threats of violence towards ZJC. There's intimidation related conduct in the underlying case. I don't think contact's appropriate.
All right, I agree. This is two Act 3 eligible offenses in less than 2 months involving the same parties. I don't know the truth of what's all happened there, but it doesn't seem like it's going well for either of you because you keep ending up with criminal charges. And I think that it's certainly a timeout for a longer period of time is probably appropriate at this point. So I'll order a signature bond. I'll order a no contact director and director with ZJC and a ban for the 200 block of South Bird Street. I'm going to allow contact with ZJC through a third party. I'm not trying to prevent you from having contact with your kids, but you're going to have to arrange through some third party. And then the only communication you have is about exchanging your kids so you can get to see them. If you can't come to an agreement on that, then somebody's got to go to family court. But absolutely, you can't have any contact otherwise, even through a third party with ZJC. You're going to be back here and there might be cash bail because there's a PSA that suggests cash bail is appropriate and you're starting to pile up what we call Act 3 offenses. That's not really good. So I wish the best for you and the victim going forward and hopefully we don't have any more issues. All right. We are adjourned.
File a motion on that, okay? So you'll get out today, but you do have those conditions that you not have contact with their residents, all right? All right, good luck.
Thanks, Aaron. You're welcome.
Next up is Nathan DWIGHT.
Nathan?
Yeah.
We'll go on the record in the state of Wisconsin versus Nathan DeBush. It's 25 CM 2488 and 26 CM 594 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Nathan DeBush appears in person and in custody, represented for today's purposes by Attorney Will Anderson of the Public Defender's Office. So received copies of the relevant criminal complaints, would waive formal reading of the 2026 complaint. Asks the court to enter not guilty pleas. The Beacon is a good mailing address.
Yeah.
The mailing address on the criminal complaints is a good one for him, and it doesn't look like he's had a chance to speak to someone from the Public Defender's Office about this new case yet.
Okay.
Thank you.
The deputy is going to hand you the public defender contact info, give them a call to see if you're eligible. So we're here in 25 CM 2488. He got a signature bond on October 17th and then didn't appear on March 6th of 2026. So we'll need to address bail there. I think at the time he had Attorney Leonard, so he'll probably still qualify, but you got to go through the process and likely they'll get you the same attorney. In 26 CM 594, I'll find probable cause, enter not guilty, please. What's the state's position on bail?
Well, in the 25 CM 2488 case, I'm proposing that you change the signature bond to a $250 cash bond, keeping the non-monetary conditions the same. And then in 26 CM 594, I'm requesting a $250 cash bond with a condition that the defendant be banned from all Madison public libraries. It looks like here in Dane County, Mr. DeBush had a bench warrant issued, excuse me, there was a failure to appear on March 6, 2026. A bench warrant was issued on March 9th. And Mr. DeBush was in warrant status when the alleged offense in 26 CM 594 occurred. I'll also note for what it's worth, Mr. DeBush appears to have out-of-county warrants issued against him. I see in in particular, I'm referencing and seeing that there's an individual named Nathan R. DeBush with a date of birth of December 22nd, 1994. With previous matters in Outagamie County, there looks like previous bench warrants were issued on.
Relevancy. It's relevant, sir. Let him finish and then Attorney Anderson's a very experienced attorney. He'll make arguments on your behalf.
That's objective.
There were multiple looks like there were 4 bench warrants issued in between February 18th, 2020 and August 23rd, 2021 in Outagamie County. I think the most relevant thing, though, is that it was a warrant status when this alleged offense occurred. Given the nature of the conduct, I think that some modest cash between the two cases is warranted.
And Attorney Anderson?
Sure. May I have just a brief moment to talk to Mr. DeBusch off the
Sure.
record?
Yeah. I was planning to serve 42 days, so I did so served it to not have to deal with probation later. If I don't take bail today, you are allowed to tell me my current Mark Leonard. Try to get to as close to 42 days as possible for time served. If I'll be trying to contact, but I verbally give permission to talk to him. I would like a signature bond in case I want to get out before then. I'm still deciding whether I want to get out today, even if I do get a signature bond.
Thank you.
I do hope for one, so I have that option.
That's the last one. All right, Mr. DeBusch. Thank you, Commissioner. We would ask that the court set signature bonds in these two matters. I can tell just from a brief review of Mr. DeBusch's file here that he lacks the means to post even the $500 cash bail that the state is requesting. It would result in him remaining in custody. It sounds like that he was close to a resolution in the 25 CM matter, and ultimately has an attorney appointed in that case and wishes to work with that attorney to work these cases towards resolution. But if the cash bail is adopted, he will likely be stuck in the Dane County Jail while that happens. The missed court appearances, I think, are quite dated, and sounds like they date back to COVID times. So primarily, we're looking at the fact that he didn't appear for court earlier this month, and was in warrant, while he was arrested on new charges, ultimately was in warrant status for a very short time. So I'd ask that the court consider signature bonds in these matters. Thank you.
All right, well, I don't think he was in warrant status in anything other than this case at the time. But I did take a look at Outagamie case 20 CF 693. It does appear there were failures to appear August 19th of 2021 and June 2nd of 2021. We've got the pretrial assessor who also has previously noted failures to appear older than 2 years. That was at the time of the initial appearance in the misdemeanor. So I don't know that he's got that information at his ready, but if he did and he sees something different than what I'm saying, he certainly should feel free to interrupt and let us know. So that's more concerning when we had the failure to appear here in this other one. It's not just a one-time incident. I think you're right. The timing was during COVID. I think in his favor when there was contact. In the new case here, he was pretty cooperative. He wasn't fighting with the cops, wasn't running away. I give him credit for that. I think it's a close call. I'm willing to go with a signature bond. I think that's what the PSAs had previously recommended. I'm not sure that that would change with this one failure to appear. I will order signature bond in 25 CM 2488 again with the prior non-monetary conditions, and in 26 CM 594. There was just the ban from the Madison Public Libraries, and there wasn't any objection to that, was there?
No, Your Honor.
I would like to object that because the library is a very important resource to use the computers. And I did my research on the 4 that are still within the bus route that are close.
Sure.
There's 4 of them, Verona, the other one in Middleton, Sun Prairie, and the one all the way in Fitchburg. I would have to go all the way there for those basic resources. If I was banned from all the libraries and the circuit court or the circuit system for the libraries.
Okay, well, I appreciate that. I've taken another look at the facts, and I think given that it's appropriate that you be banned from the Madison Public Libraries at this time. again, bond can be changed. You can have your lawyer file a motion to review that, but for the time being, it's an appropriate request and I'll order it as a condition of your signature bond in the case and will be adjourned.
Up next is LENNEL, Parker, and via Zoom.
I'm not sure if the defendants at the food slot window, I don't see them in the top window.
Doesn't want to participate.
Oh, so Mr. Parker does not want to participate?
That's correct. I have knocked countless times and he just doesn't want to budge.
Okay, well, we'll go on the record in the state of Wisconsin versus LENNEL Parker. It's 26 CF 644 and 26 CF 653. And Mr. Parker apparently doesn't want to participate according to the deputy. If he wanted to try and talk to him, I think he's in the SEG units. These are, I believe, must go hearings under Rule 206. He's entitled to have them today. If he doesn't want to, they can certainly be adjourned. And I suppose if he doesn't want to actively participate, that's also his right. But if you wanted to speak with him, Attorney Anderson, I'd certainly allow that opportunity.
Thank you, Commissioner. I think I better try, yeah.
Okay, and then I don't know if Attorney Valerio wants to let you know what the bail information that he's requesting is. We're recalling the state of Wisconsin versus LENNEL Parker 26 CF 653 and 26 CF 644. We've got everybody back. Attorney Anderson, you made an effort to speak with the defendant.
Yes, Your Honor, and the defendant's not communicating with me, and it seems like hasn't been communicating with jail staff today either. Just given the lack of communication, I think I would ask that the court postpone this hearing maybe till tomorrow if possible, and just to hope that perhaps he's in a better state and can meet with a lawyer and get a sense of his bail situation. I don't think, seeing as the state's ready to go, I don't think that I feel like I can make that request on Mr. Parker's behalf today.
Okay, any objection from the state? I don't think we had any victims who wanted to make a statement, but let me check again.
Yeah, my understanding is that there's a victim present. I don't believe they wanted to make a statement though. I don't object to this being set over to tomorrow.
Okay. Well, again, I think local court rule 206 is intended to inure to the defendant's benefit that they would get the hearing if they wanted it. So I understand the request for the adjournment, and it's a difficult position for Attorney Anderson to be in, who is maybe has no history of Mr. Parker. So we'll adjourn the matter to tomorrow, and perhaps they'll be in a better position to assist counsel.
Yhonny, Ramirez,
Briceno.
Yhonny Ramirez Briceno.
President, I was not told if the victim needs to have an interpreter. So right now, I think that this can be a simultaneous interpretation, or perhaps reaching for something.
Let's see, who's this for again? I'm sorry. Or which?
Yhonny Ramirez Briceno.
Got it. Hold on.
I think the victims on Zoom, if they need an interpreter, they can unmute and let us know.
The victim.
Entonces tenemos alguna víctima aquí compareciendo por Zoom y necesitamos saber si esa víctima realmente necesita un intérprete en español o no.
This is the sound of Lucy staying on top of her spending. You see?
I apologize. If I could interject, I don't believe the victim needs interpretation services.
Okay.
Si puedo interrumpir, la víctima no necesita servicios de interpretación.
All right, let's call the state of Wisconsin versus Yhonny Ramirez Briceno, 26 CF 637. Appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Ramirez appears in person in custody, along with student intern Luke Bagley under the supervision of Attorney Anderson. We have received a copy of the criminal complaint. We waive its formal reading. The correct address would be 6773 Schroeder Road, Apartment 1. And Mr. Ramirez is eligible for public defender services.
All right, we do have certified Spanish interpreter Fred Svensson interpreting. I'll swear you in if you would raise your right hand. Do you swear or affirm that you will truly, accurately, completely, and impartially interpret the proceedings? All right, I'll make a finding of probable cause for the charge that applies to this defendant. I think there's a DOC hold that's still in place. And then we do have a victim that I was informed wanted to make a statement. If that is accurate, they would just need to unmute, identify themselves, and then you can let us know what your position is on bail or bond.
Commissioner, what I would inform Mr. Amos is that it's now his opportunity to speak if he would like to make a statement as to bail.
And he appears to be muted, so there's a little audio icon on the lower left tab to unmute. And if
Prior to the hearing, the defense for the victim did briefly unmute. It was difficult to understand what they said. I think I heard the word Bluetooth, maybe they're having some sort of technological issue.
Oh, okay. Let me maybe. Okay. Mr. Amos, can you hear us? And if so, can you unmute and let us know whether you wanted to make a statement or not?
No. You're not too, you had shorter hair, I didn't.
Hello?
Yes, we can hear you.
Yeah.
Can you hear us?
Yes, I was trying to fix my phone. Yes, no, my thing is they broke into my the establishment 3 times and then came back 3 more times while the police was there. So I don't think it should be just a signature bond. Like I'm missing over $10,000 in equipment and tools.
All right.
They didn't care about the police or nothing. They came back 3 times while the police was there.
All right, well, I appreciate that input, and for the record, we can identify you as Antonio Amos, is that right? That's what's listed on the screen?
Yes.
All right, thank you, Mr. Amos. What's the state's position on bail?
I have no objection to a signature bond in this case. I would ask that the defendant be banned from the 5500 block of Femrite Drive in Madison. I believe that should include any parking lots associated with that address ban. I will note, because the victim in this case is asking for cash bail, we did consider that Mr. Ramirez Briceno is on probation for 2 counts of misdemeanor battery. So that weighs against his favor because he's on supervision and because those are 2 Act 3 eligible offenses. This case is allegedly an Act 3 eligible offense. But I'll note that the reason why we're comfortable with signature bonds, at least at this point, is because he has no failures to appear. So I think that at least at this point, a signature bond's appropriate.
All right, and is that the extent of his history, the 2 misdemeanors you referenced?
1 second. Yes.
All right. Defense position, any objection?
No objection, Your Honor.
All right, let me just take a closer look at things here.
He's on a signature. That's it. ¿Sabes qué es correcto? Oh, sí, bueno, entonces sí. Bueno. Entonces, sí. Signature bond.
All right, well, it's somewhat of a moot point. If the agent doesn't lift the hold, he's going to continue to be in custody. There's a relatively minimal history. Certainly no history of this type of violation. There's never been any failures to appear, ties to the area. I've got a joint recommendation from counsel. I'm supposed to give some deference to that, so I will allow release on a signature bond. I will order a ban from the 5500 block of Femrite Drive in Madison, including any associated parking lots with that. You do have the right to a preliminary hearing in the next 20 days. And Mr. Vagley may talk to you privately about that to see what your wish is on that.
Una audiencia, sí, para ver si el intento se fue cometido por usted. ¿Cómo se está saliendo por usted puede denunciarlo? Está bien para tener un abogado, todo. Yes.
Your Honor, we waive time limits on that.
Okay, we are adjourned.
Su firma allá.
Jonathan, there, GUTIERREZ.
What? Adiós. Otra pregunta. No, vaya de allá. Soy de allá. No confianza. Do I pay a bill? No, there's nothing. Yes, sir. Hey, are you leaving? No, I'm staying. You're staying. I gotta get to the hall. Great. GUTIERREZ? They just got back. Sweet. We'll see you today. I'll yeah, please.
On the record in the state of Wisconsin versus Jonathan OVALLE Gutierrez, 26 CM 602 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Jonathan Gutierrez appears in person and in custody, represented for today's purposes by Attorney Will Anderson of the Public Defender's Office. He's received a copy of the criminal complaint. We would waive its formal reading, ask the court to enter not guilty pleas. I believe I do have a new address for the court for mail. 808 808 Fairmont Avenue, FAIRMONT. No apartment, Madison 53714. And a note that he applied for and is currently not eligible for a public defender in this matter. Thank you.
Right. Sir, the deputy's given you the public defender information. Give them a call if you need to be reevaluated. You could also apply for a county attorney. That's the middle option. They can kind of point you in the right direction to file that paperwork, or you can hire an attorney on your own. For today, Attorney Anderson will assist you. We have certified Spanish interpreter Fred Svensson interpreting, and I swore him for our hearings this afternoon already. I'll make findings of probable cause or not guilty pleas to the charge. There's a public safety assessment report. It recommends a signature bond. State's position on bail.
I have no objection to a signature bond. I would ask that the defendant not operate a motor vehicle. It looks like Mr. Ovalle Gutierrez does not have a driver's license according to the time report attached to the end of the traffic complaint. I believe he was recently revoked because of an OWI, suspended because of a OWI related incident.
Right, suspended for.
An OWI related incident. And he has two operating without driver's license convictions. So you shouldn't drive at this point.
Any objections?
Commissioner, I'd ask that the condition be that he not drive without a valid license. I understand he doesn't have one now, but it does appear that if he were to complete his assessment and follow up, he would be eligible for reinstatement. So just in case he were to become eligible while this case was pending, I think that it would make sense to say not to operate a motor vehicle without a valid license. Otherwise, no objection. Thank you.
All right, well, there's certainly be an argument for cash bail, given what's alleged here. Law enforcement turns on the lights and siren, and then he takes off and he's doing double the speed limit in a residential area. I'm not trying to elicit any comments from Mr. Ovalle Gutierrez. That's generally not conduct that I think is conducive to somebody who's gonna voluntarily show up in court. Oftentimes people are getting cash bail. It looks like it was a relatively short pursuit, and at that point he was relatively cooperative, but when the lights and siren on, you gotta stop. And if the concern was, I'm gonna get another ticket for operating while suspended or operating while I'm revoked, this is much more serious than any of that would have been. So that was not a wise decision if that was the thought process. Given your prior driving history and what's alleged here, I'm just going to order that you not operate a motor vehicle, regardless of whether you get a valid license. I'll order that as the condition of your signature bond. You can have a lawyer file a motion to review that. You know, it might make sense to see whether you're going to get your license back first, and then you could have a lawyer file a motion. But given the history of the driving behavior here, I think it's appropriate. We'll be adjourned.
Next up is Brian.
Yeah, let's do it there. Next up will be Cory Webb via Zoom. Where is? Yeah, great.
One of mine.
He said Mr. Webb is by Zoom.
Yes, go pick her in a camera here.
All right, we'll go on the record in the state of Wisconsin versus Corey Webb. It's 26 CM 590 appearances.
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
Corey Webb appears via Zoom video teleconference from a segregation cell in the Dane County Jail. Corey, have they given you a copy of the criminal complaint? Could you give a thumbs up?
Mr. Webb, did you get a copy of the complaint? All right, I see a thumbs up.
So I should have said it represented for today's purposes by Attorney Will Anderson of the Public Defender's Office. He has received a copy of the criminal complaint. We would waive its formal reading, ask the court to enter not guilty pleas. The address on the complaint is a good address for Mr. Webb moving forwards, and he is eligible for a public defender in this matter. Thank you.
I'll make findings of probable cause, enter not guilty pleas, state's position on bail.
I'm recommending a $500 cash bond in this case. I'm asking that the defendant have, be banned from the Hilton Hotel, which is located at 9 East Wilson Street. I would also ask that the defendant have no contact with MDG, and that he not use or possess any controlled substance or drug paraphernalia without a valid prescription. Looks like in 26 CM 540 and 26 CM 541, Mr. Webb was released on a signature bond, and that was 5 days before the alleged incident in this case. Mr. Webb has bench warrants issued in January of 2025, February and June of 2025 as well. Look, the conduct here is primarily disorderly. He's on bail when he's doing it. He's allegedly in possession of drug paraphernalia. So I think some modest cash is appropriate.
Great, and Attorney Anderson.
No objection to the address ban or the no contact with the alleged victim in this case. I would request a signature bond. I can just tell you from knowing Mr. Webb and working with him, looking at the file here, that he is quite indigent and that any amount of cash bail will result in him being held in the Dane County Jail. Ultimately, we're talking about a Class B and a Class C misdemeanor essentially here. While Mr. Webb does have some missed court appearances, I know that he is also makes it to court quite frequently. I think that there was maybe a period during those 2025 cases where he missed court a few times in kind of rapid succession, but then got back on track and resolved those cases from out of custody. So for all those reasons, I would ask that the court consider issuing a signature bond with the non-monetary conditions as requested by the state. Thank you.
All right, well, so it looks like he may pick up cases in a rapid order. He became a repeater very recently in 25 CM 1218. He then picks up a couple of cases. One of those significantly was a resisting or obstructing case. And then he picks up a third case in a very short amount of time. And then there's 3 failures to appear, a year, just over a year. I think some cash is warranted. I acknowledge the arguments in regards to the nature of the crimes. They're probably not something that's going to result in a prison sentence. I'm willing to set a lesser amount. I'll set it at $300. I'll order a ban from the Hilton Hotel on 9 East Wilson Street and no contact, direct or indirect, with the victim with the initials MDG, and that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. And we'll be adjourned.
Right. Go, go.
Where's good at?
Brian Alejandro Naguanaga.
Right, we'll call the state of Wisconsin versus Brian Naguanaga Espinoza. 26 CF 636 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Naguanagua Espinoza appears in custody in person by student intern Luke Vagley under the supervision of Attorney Anderson. We have received a copy of the criminal complaint and waive its formal reading. Is this su dirección?
Esa es su dirección. 23, 26, am I right? Apartment 5.
The address is correct. It is apartment 5 on that. And Currently, Mr. Naguanagua is not eligible for public defender services.
All right, so the interpreter, Fred Svensson, who's already been sworn for our hearings, is interpreting. He's going to give you the Spanish version of the public defender info. So, sounds like you're not eligible for a lawyer. You can hire one on your own after today. If you can't hire one on your own, you can reapply and give the public defender's office a call. Or you could apply for a county appointed attorney. That's the middle.
I'm sorry.
Una pregunta.
Just a question.
Me están diciendo que no tengo abogado. Está bien. ¿Qué hago? Que esta corte ahorita para que es.
They're saying that I don't have an attorney. What is
Me
this?
dejarán ir.
No, they're saying you cannot afford an attorney. They're saying you cannot afford, or you're not eligible for a public defender. And they're gonna assist you today. So you have a law student, intern, and a lawyer are helping you today. So if you can't afford a lawyer after today, you've got some options to get one. You can reapply with the public defender's office, or you can apply for a county appointed attorney. And if they find that you're indigent, meaning you wouldn't be able to hire an attorney on your own, they'll get somebody appointed for you. But you've got representation here today. Okay, does that answer the question, sir?
Thank you so much.
All right. We'll make a finding of probable cause for the charge. And then we have Antonio Amos, who wanted to make a statement. This is a co-defendant with an earlier case. Mr. Amos, if you want to unmute, and then you can make your wishes known. And I know you were having trouble with the technology earlier, the connection. And obviously, I do remember his position from the earlier case. But if you wanted to make a statement here, since there isn't going to be a record otherwise, in this particular case, now would be his opportunity. I don't see that he's unmuted. Maybe we'll hear from the state and see if he's able to get unmuted before we're concluded, but obviously otherwise, I know what his position is.
Okay. I have no objection to a signature bond. I would ask the defendant be banned from the 5500 block of Femrite Drive. I would ask that include any associated parking lots.
And because I know Mr. Amos was seeking a cash bail, and I assume that's his position with this co-defendant, and I understand his reasoning for that. Is there a prior record for this particular defendant?
No.
No objection, Your Honor.
And Mr. Amos, again, I wanted to offer you the opportunity to make a statement if you wish to do so. Just need to have you on mute there. All right. I'm assuming, and it would kind of be odd, I guess, if Mr. Amos wasn't seeking a cash bail for the co-defendant here as well, given they're charged with the same charges and given his reasoning for that request with the other defendant. So I'm gonna presume that that's his wish and what he's asking for. Given the lack of any prior criminal record and some ties to the area, I don't think a cash bail is necessary to assure his appearance in court. And I don't see that it's necessary, given the lack of prior record, to protect the public. I do expect that this defendant is going to abide by the bond conditions. A ban from the 5500 block of Femrite Drive, including any associated parking lots, as a condition of the signature bond. If you prove that you can't follow those conditions or picking up other cases, then it might be cash bail territory. So don't put yourself in that position to have the court take a look at bond again. And then you're gonna have the right to a preliminary hearing in the next 20 days, and Mr. Bagley may chat with you quietly about that.
Puedes llamar aquí cuando solicitaron para una audiencia preliminar es para así usted posiblemente actualmente comisión de programa. Como ustedes han preso, pueden decidir en posponerlo más de 20 días. Y conseguir para usted sería abandonar los tiempo para poder obtener una oferta. Es una pregunta. Tienes 20 días para la audiencia preliminar. Si quieres tener más tiempo para conseguir un abogado, puedes abandonar el derecho de tener esa audiencia dentro de 20 días. Está bien. Esto es lo que entiendo.
Quiero hacer una pregunta. Primero de todo, quiero saber si ese abogado lo tengo que conseguir yo después, ¿verdad? Porque quiero saber que si hoy te van a quitar el cargo por ir a esa casa, y yo trabajando poder conseguir el dinero para luego tal vez pagar a un abogado para salir de este trámite rápido.
Vamos a hacer es semestres o llevar out. Ustedes serán esta noche afuera. Cáncer de promesa va a salir hoy. Vas a tener la oportunidad para ir al defensor público a ver si se le pueden asignar un abogado o usted puede contratar a tu propio. La pregunta para usted es: ¿quiere renunciar el mínimo de tiempo para tener más tiempo a conseguir su abogado? ¿O quiere tener suficiente ausencia dentro de los 20 días?
Dentro de 20 días, no se preocupe, yo mañana mismo.
Okay. Your Honor, we're not waiving time limits.
Okay, we'll be adjourned.
Taylor?
Thank you.
Is that it for you, Fred?
That's it for me.
All right, thanks.
All right, good to see you. Yeah. How long ago was that? The fire? Year ago, yeah, but I've just got hired here, so. Oh, that's great. Awesome, that's great. Good to hear. Let's see you working on your that Spanish lesson. Taylor? Taylor.
Great, we'll go on the record in the state of Wisconsin versus John Taylor, 26 CM 603 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
And John Taylor appears in person in custody, represented for today's purposes by Attorney Will Anderson of the Public Defender's Office. Received a copy of the criminal complaint, and we waive its formal reading. Ask the court to enter a not guilty plea. And the address on the complaint is a good mailing address for him. And at this point, he is not eligible for a public defender. It looks like he has a private attorney retained in his other matter. Thank you.
Okay, so Mr. Taylor, we should talk about that. They've given you the public defender info if you need it. If you're able to hire the private attorney you have on the underlying case, great. If not, you can reapply with the public defender. You can apply for a county attorney. That's the middle option. Attorney Anderson's going to assist you here today. I'll make a finding of probable cause, enter a not guilty plea, state's position on bail.
I have no objection to a signature bond. I would ask that the defendant have no contact with Tanisha J.
Any objections?
No, Your Honor. I'll answer that briefly.
Okay, we'll order a signature bond. Condition will be a no contact, direct or indirect with Tanisha J. Be adjourned.
Contact the police, restraining order paperwork at the clerk of courts, first floor of the courthouse, down the street, okay? But you'll get out on a signature bond today, but you can't have contact with her, and right now it only goes in one direction, okay? So you no intentional contact with her. All right, good luck to you, okay? You're all done. You'll sign your bond in there. Yep.
Right, we'll go on the record in the state of Wisconsin versus Nicole Ace is 26 CM 591 appearances.
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
Nicole Ace appears via Zoom video teleconference from a segregation cell in the Dane County Jail. Represented for today's purposes by Attorney Will Anderson. I'm here in the courtroom from the Public Defender's Office. Ms. Ace, could you give us a thumbs up if you received a copy of the criminal complaint? Document explaining the charges in this case?
Thumbs up.
Seen it? Thumbs up from the bailiff, looks like.
Ace, did you get the criminal complaint?
All right, she's given a thumbs up as well. So we'll acknowledge receipt of the criminal complaint and we'll waive its formal reading. Ask the court to enter not guilty, please, on Miss Ace's behalf. The address on 6th Street in Nakusa, Wisconsin is the correct address. And she is eligible for a public defender pending some verification that my office is engaging in right now. Thank you.
All right, so Ms. Ace, we're gonna have the bailiffs give you the public defender information. Check in with them to see what the status is on the verification. I'll make a finding of probable cause for the charges that apply to this defendant. Enter not guilty, please. State's position on bail.
I have no objection to a signature bond. I would ask that the defendant have no contact with Abraham E. Hillsburg, and that she not use or possess any controlled substance or drug paraphernalia without a valid prescription.
Right, any objections?
No objections, Commissioner.
Right, we'll order a signature bond. Condition will be a no contact direct or indirect with your co-defendant Abraham Hillsburg, and that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. And we are adjourned.
Measure.
Okay, well, I guess he was on a warrant, so we can set him over to tomorrow.
Okey-doke. Yes.
Oh, and he's also got holds in other counties. Going nowhere.
So.
Great, we'll go on the record in the state of Wisconsin versus Maurice Smith. It's 26 CM 589 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Smith appears in person in custody by student intern Luke Vagley under the supervision of Attorney Anderson. We received a copy of the criminal complaint and waive its formal reading. The address on the criminal complaint is correct. And we have no information at this moment as to whether Mr. Smith is eligible for a public defender.
All right, so Mr. Smith, they're going to give you some information about contacting the public defender's office. If you're not able to hire an attorney after today, you can give them a call to see if you're eligible for one. If you're kind of caught in the middle, you could apply for a county attorney. We'll make a finding of probable cause for the charges and are not guilty, please. State's position on bail.
I'm requesting a $500 cash bond in this case with the condition that the defendant have no contact with Elizabeth M as in Mary and no contact with Amy B as in boy. Amy's first name is spelled AIMEE. I would also ask that the defendant be banned from the 4,000 block of Nakusa Trail. It looks like bench warrants were issued in the past on April 23rd, 2024. March 26, 2024, and June 6, 2022. In this case, it appears that Mr. Smith was on bond in 25 CM 2516, where $500 cash bail was ordered in that case. So I think that similar amount of cash bond should be applied here.
Okay.
I have a moment to speak with Mr. Smith.
Sure.
Mr. Smith. Your Honor, we don't object to the non-monetary conditions. However, Mr. Smith is indigent. We would request a signature bond. He does have extensive connections in the community. He's been living here for 20 years. His siblings live here. Nothing further, Your Honor.
All right, let me take a closer look at things. So it looks like in that underlying case, he did have $500 cash bail. Coincidentally, that was set by me. Then I don't think it was posted. He got a signature bond in February. So he wasn't out on a cash bail at the time of this particular charge. These charges are, I think, less serious than a completed battery, which he was out on bail for. I'm concerned about the failures to appear. We've had several of those in the last couple of years, and one within the last 4 years or less. It's a close call. I'm going to give him one last opportunity on a signature bond. I'll order no contact direct with Elizabeth M. and Amy B. You got to be banned from the 4,000 block of Nakusa Trail. Is there some better place you can get mail, Mr. Smith? Like the Beacon or some other shelter or Aberg Job Center or something?
The jobs are.
Okay.
I'm still fighting case there too, so the jobs and.
Okay, we'll update it to the jobs. Do you have a cell phone? If so, you can sign up for text message reminders just to make sure you make your court dates, and you kind of got to stop picking up cases. Otherwise you may get cash bail again. I appreciate that, but it's also a bail factor for a reason why cash bail is set when you're out on bail and picking up other cases. So you gotta do multiple things. All right. Good luck.
Richard Yeager.
We'll go on the record in the state of Wisconsin versus Richard Yeager. It's 25 CM 2799 and 26 CM 605 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Richard Yeager appears in person and in custody, represented for today's purposes by Attorney Will Anderson of the Public Defender's Office. He's received a copy of the new criminal complaint, and we would waive its formal reading. Looks like the address on the criminal complaints is the correct address for him moving forwards. At this point, he is not eligible for a public defender in these matters. Thank you.
Deputy's going to give you the public defender info. If you can't hire an attorney after today, you could apply for a county attorney. That's the middle option. The public defender can help you with that. Or you could reapply with the public defender if you thought they didn't do the calculations right.
Yeah, last couple of times they have, although I've had issues with their office. This time my income hasn't changed, and
Well, you can always give them a call and have them run the numbers again.
I just don't understand what the difference is.
Sure.
This time.
So in 25 CM 2799, that went out on a warrant. So probable cause has been found there. I'll find probable cause in 26 CM 605. Enter not guilty pleas there. And state's position on bail.
In 26 CM 2605, I'm requesting a $250 cash bail with the condition that the defendant had no contact with Sean H. And then in 25 CM 2799, I'm also requesting a $250 cash bail with a condition that I don't have any specific non-monetary conditions to provide in that case. It looks like in Mr. Yeager was given notice in hand after bailing out on October 13th. He failed to appear in December, and he was only picked up due to new criminal activity. It looks like in
I call. We'll get to him.
I don't know if this covers what I alluded to. It looks like there was a failure to appear from December 2025, which he missed his IA after a jail bailout, which I just alluded to. And then it looks like there was also a miss from March 3rd, 2026. Looks like that was for a jury status hearing. Given the fact that he now has, I think, let me just double check here. So now he's got 3 cases open now. I think that some modest cash is necessary.
All right, and I think he posted $1,150 cash bail that was forfeited in the one case. And is there a warrant still in that other case you referenced with the failure to appear on a jury status?
I don't see any active warrants. The only bench warrant I'm seeing is from March 3rd, 2026 in Dane County that was issued on.
So it looks like there was a body only warrant in 25 CM 1826 issued by Judge Burrs. And I don't see that any bail had been set on that or a bail hearing set, so I think that's still something he has to address with branch 11.
That's
I think
correct.
so.
It's not active in that it's still waiting to be served, it's been served and waiting to be scheduled. It's being held by.
All right, Attorney Anderson, your position on bail?
If I could just have a brief moment to talk to Mr. Yeager.
Thanks. Sure.
Let's grab these quotes.
So she was on this, but she breaks down.
I've been waiting since the meetings to talk to anybody other than Gar. And then. See, it's all sorts of problems. This is it. What I do now, what I did then. It caused all sorts of problems. With this one, which I just want to be this. Ludicrous. Told me a few times I should have given to him. I didn't, and I didn't. So I was very upset, but whatever it is, I don't have. I was ahead with me cash. I actually a couple days ago, so I access them. So whatever.
All right. Thank you, Commissioner. Would be requesting that the court consider issuing signature bonds in both of the cases that are before your honor today, understanding that he will be brought into branch 11 soon for a bail hearing on that case as well. Ultimately, what we're looking at is disorderly conducts here. I note that the one disorderly conduct actually occurred in the Dane County Courthouse. So at least at some level, Mr. Yeager makes it to court. He did miss court earlier this month. My understanding is that he had recently lost his phone and his wallet. He now has a phone. I believe that he would be able to get in touch with his attorney. He has a very limited means at this point and has less than $200 to his name to address bail potentially in all of these cases. So given all of those circumstances, I would ask the court consider signature bonds in these essentially these disorderly conduct cases. Thank you.
All right. Well, in some sense, it's moot, at least right now, because you can't get out regardless of what I do for bail, whether I said cash bail or signature bond. I can't see these as signature bond cases, though. You forfeited $1,150 in cash by not showing up in December, then didn't show up for a pretty important thing, a jury status, then picked up yet another case. The state, I think, could have made a credible argument for a higher amount of cash bail, taking into account what these charges really are at the end of the day. I'm not going to go above what they asked for, but I'm not going to go below it either. I'll set $250 cash in each case, and the new case order, no contact, director and director with Sean H. These are all going to go, I assume, presumably to branch 11. She's still in the criminal rotation, and you can have your lawyer file a motion, and she can address bail, I guess, on all 3 of them if a motion gets filed at the same time. So
That's right.
we'll be adjourned.
Okay. Well, you already have to see Judge Burrs. All 3 of these cases will now be Judge Burrs. If your lawyer files a motion in these 2, then Judge Burrs can address bail in all 3 at the same time at your next court date. So talking to your lawyer.
I'm sorry, so the court grant, so it did $250 on each one?
Right.
Okay, got it, with the non-monetary condition.
The
Okay,
Sean H or whatever it was.
yes, okay, got it, thank you.
There you go.
Shepherd? Go on the record in the state of Wisconsin versus Demetrius Shepard. It's 26 CM 599 appearances.
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
Mr. Shepard appears on Zoom by student intern Luke Vagley under the supervision of Attorney Anderson. We have received a copy of the complaint. We waive its formal reading. Mr. Shepard is eligible for public defender services. Mr. Shepard, is the address, do you have a copy of the complaint, Mr. Shepard?
Yes, I do, and I'd like to speak to someone, please.
Is the address there correct? You want to go back? We can go back. Okay.
It looks like Mr. Shepard is actually housed in a different building.
See the address on here?
Say, I think they could probably set up a private conversation through Zoom, but if we could just maybe finish the perfunctory stuff with address and eligibility, Mr. Shepard, they'll get a chance to talk to you, so just hold tight.
He said, yes, that's the correct address.
Okay. And he was eligible for a public.
That's correct, Your Honor.
All right. So I'll make findings of probable cause, enter not guilty, please. The PSA report recommends cash bail. And then why don't we hear the state's recommendation, and then you can have a private breakout room with Mr. Shepard.
I'm recommending a $500 cash bail in this case with the condition that the defendant that he be banned from any Woodman's location. Right. It looks like there were previous failures to appear on May of 2024, July of 2024, December of 2024, April of 2025, and June of 2025, several of which occurred after Mr. Shepard posted cash bail. So I think that some cash is needed here.
Okay, so we'll take a brief recess, Mr. Shepard. The lawyers are going to talk to you privately, okay?
All right, thank you.
Yep, you're welcome.
Can you hear? Said my lawyer's gonna talk to me, right?
Mr. Shepard, can you hear me? Oh, let's go.
Where is? Oh, join breakout room? No. 1 second. Can you, I accidentally bumped you out.
You should be able to join the breakout room, otherwise it'll take me a full minute for the room to close.
As soon as it loads. It'll take a few minutes.
We're back on the record in the state of Wisconsin versus Demetrius Shepard. It's 26 CM 599 appearances as before. Mr. Vagley, you and Attorney Anderson had a chance to speak with Mr. Shepard. I'll hear any argument you have on bail.
Your Honor, Mr. Shepard has agreed to a Chapter 51 and currently has a caretaker through Journey and is required to take medication. These cases actually predate that Chapter 51, as far as I am aware. And he is currently on medication. In the past, he has been off medication and has missed court dates due to the lack of being medicated. Currently with his caretaker from Journey, he will be and is mandated to be taking that medication. He does have ties to the community, including siblings and extended family, and has lived here for 17 years. We'd be asking for a signature bond. Thank you.
Okay, and any response from the state?
No, I rest on my previous argument.
Commissioner, if I may, Attorney Anderson,
Sure.
Just add one piece of information. The only thing I wanted the court to know is that, well, Mr. Shepard does have that other 26 CM case where he posted $200 in cash. These alleged retail thefts actually occurred before he posted that amount of money. So these are kind of catching up to him while he's in custody because allegedly they're on video. And the only reason I bring that up is that I do believe that Mr. Shepard, with being under the 51, having that connection with the CARES team, having posted that $200, while it may look like kind of going backwards to give him a signature bond in this case. I actually think it would be kind of giving him a chance to make an appearance on all of these cases with that cash posted, and now that he is connected to that resource for the mental health meds. So just wanted to be clear about the timeline there. Thank you.
Okay, well, the clerk had popped me up and said that despite Mr. Shepherd's assertions, the 51 had occurred and he was under that before these new dates of offenses. So I guess I don't want to go through the record too much other than that, because it's a 51 where he could have a closed hearing at that if he wanted. He's kind of voluntarily provided some of that information. I understand why. I think given the sheer number of failures to appear relatively recently, some cash is necessary here. Taking into account the nature of the crime being a nonviolent property offense, I'll set it at $200. I'll order a ban from all Woodman's locations and we'll be adjourned.
Up next is Abraham Hillsburg.
Great, we'll go on the record in the state of Wisconsin versus Abraham Hillsburg, 26 CM 592 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Abraham Hillsburg appears in person and in custody, represented for today's hearing by Attorney Will Anderson of the Public Defender's Office. Has received a copy of the criminal complaint. We would waive its formal reading and ask the court to enter not guilty, please. The address on the criminal complaint is an accurate mailing address, and he has applied for and been deemed eligible for a public defender in this matter. Thank you.
All right, I'll make a finding of probable cause, enter not guilty, please. I don't see a PSA state's position on bail.
I have no objection to a signature bond. I would ask that the defendant have no contact with Nicole M. Ace and that he not use or possess any controlled substance or drug paraphernalia without a valid prescription.
Objections?
No, Your Honor.
Great, order is signature bond. Condition will be a no contact director or direct with the co-defendant Nicole Ace, and that you not use or possess controlled substances or drug paraphernalia without a valid prescription, and will be adjourned.
That's okay. Good luck, Jim.
Go on the record in the state of Wisconsin versus Rudy Garcia. It's 26 CM 583 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
One moment, Mr. Garcia. Rudy Garcia appears in person and in custody, represented for today's purposes by Attorney Will Anderson of the Public Defender's Office. He has received a copy of the criminal complaint. We would waive its formal reading, ask the court to enter not guilty pleas on his behalf. The address listed on the criminal complaint is the correct address of the Beacon, and he is currently eligible for a public defender in this manner. Thank you.
Right, I'll make findings of probable cause, enter not guilty pleas to the charges. The public safety assessment is recommending cash bail. State's position on bail.
I'm recommending a $500 cash bail in this case. I'm asking that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription. That he not use or possess any dangerous weapon as that's defined by the Wisconsin statutes. That he not have any contact with RFGH or JIS, and that the defendant be banned from the 0 to 100 blocks of Fair Lane Court in Madison, Wisconsin. I will note that the victims in this case are in support of that request of that whole bail recommendation. It looks like Mr. Garcia has 2 open cases, both with signature bonds. Bench warrants were issued previously on June 12th, 2025, December 20th, 2024, October 22nd, 2024, November 22nd, 2021, and November 1st, 2021. So given all that, I think that some cash is needed.
Right, Attorney Anderson.
May I just have a brief moment to speak to Mr. Garcia off the record?
Sure.
Thank you, Commissioner. At this point, we would be requesting a signature bond in this matter. I think no objection to the non-monetary conditions, that those would serve the function of protecting the public in this case. Mr. Garcia is indigent. You know, he uses the services at the Beacon. He hasn't worked in nearly 2 years. So any sort of cash bail would prevent him from bailing out and leaving the jail. Asking essentially to prevent contact with these people, prevent him from possessing controlled substances, prevent him from going near the address where his family lives, where this allegedly occurred. Those would be sufficient to protect the public, and given his limited means, would ask the court consider a signature bond. Thank you.
All right. Well, the PSA has him at the very top of the scale for new criminal activity, failure to appear. I don't remember the exact percentage, but it is an extremely small percentage of the Dane County population that actually meets that criteria, where they score out the complete worst you can score on a PSA. He's out on 2 other cases that they haven't been pending for very long. So he's picked up his 3rd case in relative short order. He was allegedly resisting obstructing in 26 CM 227. I guess in his favor here, there isn't any of that sort of behavior alleged. It's a possessory drug offense and something that's not charged out as a Act 3 eligible offense. Then there's a slew of missed court dates in the last 5 years. I think there's got to be some cash here. I'll set it at $300. I'll order that you not use or possess controlled substances or drug paraphernalia without a valid prescription. That you not use or possess any dangerous weapons, as that term is defined by the statutes. That you have no contact, direct or indirect, with R, F, G, H, and JIS. A ban from the 0 to 100 block of Fairlane Court, and will be adjourned.
Next up is Earl Williams.
They're calling Williams. That's the last one. Do you want to do that last one? This one.
We'll go on the record in the state of Wisconsin versus Arella Williams. It's 26 CF 659 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Arella Williams appears in person and in custody, represented for today's hearing by Attorney Will Anderson of the Public Defender's Office. She received a copy of the criminal complaint, would waive its formal reading, ask the court to, never mind. We don't have any misdemeanors to enter a not guilty plea to. I would note that the address on the criminal complaint, you'd like him to go to the job center instead of to Bram Street. If we could update the address to 1819 Aberg Avenue in Madison, 53704. And a note here that Ms. Williams has applied for and been deemed eligible for a public defender. Thank you.
Right, thank you. I'll make a finding of probable cause, state's position on bail.
Sorry, 1 second. Okay. Well, I'm recommending a $750 cash bond in this case. I'm asking that the defendant have no contact with Desiree G. Their first name is spelled Desiree. To be 950 compliant, I'll note that Desiree G would like contact with the victim, or excuse me, would like contact with the defendant rather. However, I'm asking for that no contact anyway. It looks like Miss Williams has an open CF case with the same alleged victim, where in that case, it's alleged that Miss Williams locked the victim in the basement of their shared home with a padlock. And then within a month of her initial appearance on that case, Miss Williams is having contact with the alleged victim here in this matter. For what it's worth, Miss Williams was previously convicted of disorderly conduct as an act of domestic abuse in 22 CM 1927. That involves the same alleged victim in this case. And the reason why I paused was because it looks like there's a note in my file saying that there was some type of extradition matter in connection with Kenosha County case number 14 CF 1220. I don't have that handy right now. Oh, I see. So I see 14 CF 1220. Yes, it looks like that the disposition date in that matter was October 28, 2014, though that's a while ago. And I think I believe Miss Williams has an address here. I think the primary concern is with the fact that the underlying case is certainly serious, and Miss Williams should not have had any contact with the alleged victim, and she's having contact that's in violation of her bond on a rather serious case. And I think that some cash is necessary.
And Attorney Anderson.
Commissioner, we would be requesting a signature bond in this matter. Ms. Williams lacks the ability to post any amount of cash bail. Ultimately, I guess what happened here is that Ms. Williams needed a ride to work. Obviously, that's not an excuse for potentially violating the bond condition, but there's no allegation here of even a disorderly conduct or any sort of violent behavior. I haven't had a chance to do a full review of Ms. Williams' court appearance history, but it does seem like, not having heard much, that generally Ms. Williams is making it to court. Understand that when you've got cash bail posted in another case and you come in, that there is some expectation that there will be cash bail in the new case. But I would just say that the trip to jail, having to go through all of this, I think gets the message across. And note that it seems Ms. Williams is acknowledging that she can't return to that Bram Street address, needs to use a different address for mail and all sorts of other things. So I would hope that just the fact of the case, the arrest, the new felony matter gets the message across, and that additional time in jail on cash bail would not be necessary. So a signature bond would be appropriate in this matter, and I'd ask the court consider it. Thank you.
Just to clarify one point, I don't think she's out on cash bail in 26 CF 412. She's out on bail, but it's a signature bond. The PSA there had her a 3 out of 6 on new criminal activity, a 2 out of 6 on failure to appear. So she's apparently never missed court, at least according to the PSA that they're aware of. The extradition is pretty dated. I'm just not going to really put any weight on that. I think the thing that's the strike against her is the alleged contact here. I'm going to give her one more opportunity on a signature bond, but you got to stay away from her. You're having contact with this person. I don't care if they decide they want contact or they call you or invite you over. You have contact with them, you're going to get in trouble, and there's going to be a pretty good argument for cash bail at that point. So signature bond, no contact, director and direct with Desiree G. What about time limits?
Do you want to have your next court hearing in about a month? You could, Sean. Yeah, if you want it, or you can waive it. It'll be prelim.
Attorney Anderson, Ms. Williams already has a prelim related status conference scheduled for April 13th. If that limits are waived, that's taken consent.
Then what we could do is waive time limits here and set this for a status conference at the same time. You got it, Ms. Williams.
I don't see you.
The status conference, not.
Oh, no.
I don't usually do those, but occasionally I do. I have no idea where I'm scheduled that day. All right. All right, the last two. There's 2 more.
Call. Then create disturbance and does not want to participate in the hearing.
Oh, well, then it sounds like she wants to stand mute. We'll enter a not guilty plea. And we'll be done with hers.
The next one is oral Garrett.
Yep, so we'll need to do hers. Great. We will go on the record in the state of Wisconsin versus Laurel Garrett. It's 25 CM 1640, 25 CM 1670, and 25 CM 1938 for bail bond hearings. Appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Laurel Garrett appears in person and in custody, represented specially by Attorney Will Anderson of the Public Defender's Office. Good afternoon.
Good afternoon. So looks like in 25 CM 1640, we had a failure to appear on December 3rd of last year. It's like and 25 CM 1670. The failure to appear was also on that date, and I'm gonna guess that's the same for 25 CM 1938. Yeah, and it looks like because of the amount of time she's been on the warrant, Attorney Dickey may have closed out her case. Is she gonna be eligible for an attorney going forward?
Oh, thank you for asking. It looks like eligible pending verification, so our office is working on.
Okay, just make sure you give them a call. We'll make sure you have their contact information. And then the last address we had, I think, was the Beacon for all these cases. Is that still the best place for mail?
Yeah.
All right,
Yes.
and then any info you want to provide, Attorney Anderson, about the failure to appear?
If I could just have a moment to speak to Ms. Garrett, please.
Sure.
Let's talk just real quick about that, okay? Great. Thank you, Commissioner. We'll be requesting signature bonds in these matters. I think ultimately, the information that I have is that after Ms. Garrett, after Ms. Garrett was released from custody in November of, January of 2026. You were out of town for a little while, and ultimately was not able to pick up court notices at the Beacon, and essentially just fell out of communication with the court. Is now back in town, is back to using the services at the Beacon, and to all accounts to be, accountable for this. There's no new criminal conduct alleged, just the bench warrants to address here. So, given that there's an obvious lack of financial resources here, I think Ms. Garrett receives about maybe $1,100 in retirement income, and that's it. So does use those services at the Beacon, and what just was out of town, and the mail was not forwarded on, and ultimately missed notices of court. So would ask that the court consider reinstating signature bonds, or ultimately I think all these cases were in signature bond posture. Thank you.
All right, and Attorney Valerio, what's the state's position?
My understanding is that Ms. Garrett's currently on signature bonds in all of her cases right now, is that right?
I believe so.
Okay. Well, in 25 CM 1640, I'm recommending a $500 cash bond. And then in 25 CM 1938, I'm recommending a $500 cash bond. And then in 25 CM 1670, I'm recommending a $250 cash bond. I believe those were her original cash bond amounts before they were converted to signature bonds.
I think she had, so in 25 CM 1640, she started out with a signature bond. There was pretrial services. It doesn't look like that worked. I set $500 cash bail, and then that got reverted to a signature bond back looks like August 20th, 2025 by the judge, but then looks like there were continued violations, and then it got bumped up to $750 on August 25th. In that particular case.
Okay, I see that too now. All right, then in
250 was in 1670, like you said, and then the other one Yes, was originally a $500 cash bail.
Okay, so then I would amend my position and say that in the 1640 case, it should be reverted to a $750 cash bond. Yeah, so Ms. Garrett was in warrant status for over 3 months. It looks like the bench warrant was issued in December of last year and was in warrant status until March 14th, 2026. It looks like she was picked up on a different matter that was not ultimately charged by our office. However, it's not like Ms. Garrett's turning herself in or anything like that. I'll also note that there was a previous bench warrant issued on July 24th, 2025, though now that you mentioned the pretrial service violation, I'm not sure if that was a bench warrant for the pretrial service violation.
I didn't come across any failures to appear in these 3 cases. The warrants were for violations of pretrial services as far as I could see.
Okay. Still, I think that given the fact that Ms. Garrett's been in warrant status for that long, I think it just makes sense to revert to the original cash bonds that she had before they were turned into signature bonds.
Right, and Attorney Anderson.
I guess all I would say is, as I reviewed the bond history, I noticed that essentially any amount that was set resulted in Ms. Garrett remaining in custody until the statutory speedy trial deadline reverted the bonds to signature bonds. So we're just with that in mind, I understand it's kind of a tough position to be in, to be asking for signature bonds, but at the same time, I think that any amount of cash is going to have the result of keeping Ms. Garrett in custody for the foreseeable future. Thank you.
All right, well, unfortunately, she hasn't done all that well on bond. She's picked up other cases. We've tried pretrial services when she wasn't able to post the cash. That didn't work. And then she got another opportunity. It looks like that didn't work as well. And then she's been out on the warrant for 3 months. I'm willing to set the cash in a lesser amount. I think we got more information about, maybe where her ability to pay is, but I just can't see signature bonds or doing pretrial services again. It hasn't worked, unfortunately. So I'll set $150 in the case ending 1670. In case ending 1640, I think that's the most serious case. I'll set $500 there, and the case ending 1938. I'll set $250 there. All the prior non-monetary conditions will remain. So that's lesser bails than you've had previously in these cases. It's the best I can do, Ms. Garrett. We'll be adjourned.
Take a break on the case soon. Figure things out. All right, good luck, Mr. Garrett.
All right.
Everyone said.